If all, is it on? If all of you will take your seat, please. We have 3 bills today, and we've got to be out of here by 4 o'clock. We are really having to look at our time. This is the Subcommittee on Public Safety, Subcommittee B, and I'm glad to see each and every one of you here today. We do have a sign-up sheet, and the first bill that we're going to take up is the substitute to House Bill 439. 439, and there is an LC number that we need to look at on that substitute, and it is LC 393164S. And the presenter today is Chairman Hitchens. And Mr. Chairman, if you would please, you may proceed.
Thank you very much, Mr. Chairman. I appreciate the opportunity to present the bill today, and I think this is a pretty significant bill. It's I've been I spent 43 years in law enforcement, and I've seen a lot of tragedy occur with regard to DUI drivers. And I can remember when to be arrested for such an offense was seen to be a minor character flaw, and they slapped your wrist and gave you a $20, $25, $30 fine and sent you on your way. I've been fortunate enough, having been the commissioner of the Department of Public Safety for many years, to be engaged with Mothers Against Drunk Driving and some other groups who have brought it to the attention, not only in Georgia, but throughout the nation, of the seriousness of driving while you're intoxicated. And as a result, it's a very, very different world we live in today with regard not only to how many people do it, but what the penalties are. And there's a little bit of new technology out there now called the ignition interlock, and that's typically what most of this bill. You'll see it's 30 pages long, but the highlight of it is utilization of ignition interlock. And we've got an expert here that's going to go in a little bit further depth about it and maybe give a demonstration. But what it does, it's like an alka sensor and an intoximeter. And when you get in your vehicle and try and start it, you have to blow into the device, just like the alka sensor or the intoximeter. And if you've got too much alcohol in your system, your car won't crank. Unfortunately, alcoholism and many of the people who do this routinely have an addictive personality. I mean, and you've heard it many times say that alcoholism, drugs, some of the addictive circumstances people find themselves in are diseases. But from my perspective, and having dealt with it for many, many years, no matter what the law is, you will not stop these people from driving. You can arrest them, you can suspend their driver's license, you can take the tag off the car, and they're going to get out and drive anyway. And I think a lot of people, this even has a special, the new interlocks have a special capability in that even if somebody else blows in it and gets your car going, when you get in it and drive down the road, it requires you to take another test. And if you fail that test, it slows down and gives you the opportunity to pull over and stop, but it negates your ability to drive around. So I'm gonna turn it over here to some other people. But what it really does is, on your first offense, you can immediately apply for a limited driver's license if the judge requires you to put an interlock in your vehicle. Second offense, you have to wait 180 days. If you fail the test or for some reason it gets revoked, you have to serve your full suspension time. So it's a benefit to those people who get caught. I was just telling Chairman Petrie there a minute ago, many years ago, I saw a survey, and I don't know how they did it, from Michigan State, and they do a lot of things with regard to traffic safety. And you could drive in the United States back in the 70s like 240 times while you were under the influence before you got caught. That's reduced in today's society to about 70 times, but it only takes one time, and some people are I think you ought to get a mulligan in this, and the first time ought not count, but I differ from that. And you can kill somebody anytime you get behind that wheel and you're intoxicated and you don't have your faculties about you. So I'd like to turn it over to Solicitor General from Henry County. I think she's the expert. I've talked to her many times, and she prosecutes these cases and she knows it very well. So want to identify yourself?
That was gracious. I don't know.
Yeah, go ahead and tell everyone who you are, and we'll let you go ahead and explain.
Yes, sir. I'm Pam Bettis, Solicitor General in Henry County. That's just a fancy word for prosecutor, and we prosecute all of the misdemeanors in traffic, similar to the other counties that have solicitors. And this bill has some public safety positives to it, and that it, requires individuals who have been arrested potentially and have a dangerousness factor to have an ignition interlock while they're on bail if a judge so sees fit. And then also when they get arrested and convicted for the DUI, they're required to have the ignition interlock. And that provides some public safety benefits, I believe, in that if they're driving and they consume alcohol and they blow into it, just like Mr. Hitchens says, that their car won't crank or it'll stop running. I'm not sure if you have any certain questions about the bill. I'm mostly an expert at eating, not really much else, but I'll do my best to answer any questions you may have.
Do we have some questions from the members of the committee? Okay, Representative Evans.
Thank you, Chairman. And Colonel, thank you for bringing this bill, and thank you for being here today. So I have seen this demonstrated yesterday, so I'm appreciate that very much. But one thing I do want to just clarify, because I thought that this wouldn't be used until after they'd been convicted of a DUI, but you are saying that in this body of the bill, can you show us where it says that a judge can,
Yes, ma'am.
because it allows it on bail if the judge sees fit?
Line 40, section 1, and it starts at line 40. It can be a condition of bail to obtain an ignition interlock limited driving permit from DDS, and it's only if the judge believes the person poses a significant risk to him or herself or the community.
Mhm.
So there's, a pretty strict requirement. They have to show a significant risk. That could be someone that maybe has recently been arrested and had several DUIs back in their younger years and may have had a time where they rehabilitated, but then something has happened in their life and they've fallen off the wagon. And they may think, okay, this is someone that maybe pose a danger and continue to offend. It could be someone that, had additional substances in the car, open containers, or dangerous driving with it, just whatever the judge in their discretion would believe.
But this does count if they're subsequently convicted and they set it for 180 days. This counts as time served, just like being in prison or jail. So the clock's running if they have to put one in as a requirement for bail.
Time toward their suspension.
Right.
Can you talk to us about if you're an indigent?
Yes, so there are some provisions in the bill that if a judge determines that a person is indigent, there's several things they can look at. If they're on TANF or Social Security or other things that they can show the court, then they can get an ignition interlock installed for free and then pay half the cost. So they can still comply, but it's not as, it's a little bit more cost saving for them.
Okay. Let me,
And if they live more than 100 miles away from where they can get it installed, they're exempted from it.
who's 26 down there? All right. Representative Williams.
If you live more than 100 miles away from where they have an installation facility, you're exempted from interlock.
So
It would be such a burden on you to try and go back because you have to get it recalibrated once a month. So they put an exemption in there. And my guess is if this moves forward, there are going to be some more people putting interlocks in, and they'll be in closer proximity to the major, at least the major urban areas.
One other question I had, Mr. Chairman. say you got this interlock thing on your automobile and you went through all the probation and everything and you were, okay, you can take it off. You're allowed to resell it?
It would go back to the company. They would, recalibrate it and then use it for the next individual that may need it.
Okay, so you don't actually have to pay for it and buy it.
You don't buy it, you pay a fee each month for the company to monitor it and track it, and to, of course, install it into your car.
Okay.
But it wouldn't be yours at the end of it. And I doubt many people wouldn't want it, but for their teenagers.
Yeah, I mean, I don't know. Down in South Georgia at Peaches District, I've seen some weird trophies on the wall down there.
Thank you, Representative. Do I have other questions from the committee? Okay. All right. All right.
Just to be clear, thank you, Mr. Chairman. So speaking to the issue of making sure that indigent can pay for it, interesting comment. I mean, they certainly don't have a problem buying booze and jumping in a car. But at any rate, my point is, what is the cost for someone who is paying their fee for leasing this as described herein, so we understand the real cost of this?
There's an installation cost that I think runs $600 or so. After that, it's a $60 a month rental. And under the law, they're required to have it recalibrated every 30 days, which you run you another $15. So the actual rental cost is about $3 or $4 a day.
So in the aggregate, if someone were to have it over the timeline, kind of anticipated here, it's going to be a total cost of about what, Chairman Hitchens?
Probably $1,500.
$1,500.
Just a guess.
Okay.
I wasn't a math major.
And half of that for those that might be indigent, as you described, and have basically, my understanding is the vendor or the manufacturers, and that they are going to eat half of the cost for those that the judge determines cannot afford to pay that.
And for someone that's indigent, and they're serving their sentence, you can do community
Speaking
service.
to the mic, please.
You can do community service for your fines. So there's things you can do even if you're indigent to work toward being accountable for the crime. So with this, to have it installed for free and then half the cost, that helps because they still may have probation fees. So that while they're doing community service on top of the community service they're sentenced to, they're doing the extra to pay off their fine, they would have these fees as well.
Okay, thank you. Thank you very much.
Okay. Who's 16?
Me, Mr.
All
Chairman.
right. Go ahead.
In your testimony, you were saying that, and I believe talking to some other people about the bill, it's about 70 times somebody has driven intoxicated before they're actually caught. Is that what you said?
That's on average. Somebody, if you're, I've seen some 15, 16-year-olds that are intoxicated that first time out, they couldn't keep the car on the road. And it's pretty obvious then they may get caught in an earlier stage, but on average, it's about 70 times.
Wow. And then a follow-up to that is how often, if in a case like this, if it is somebody's first time, does it get pled down to some kind of lesser charge like reckless driving or something like that?
Well, that does occur.
Well, I'm not sure if you're familiar, but prosecuting DUIs has become very difficult recently with various cases that have come down from the Court of Appeals. And, if a person decides to refuse to do fields and refuse to provide a breath test, then there's not a lot of evidence that a prosecutor has to prosecute the cases. But there are some, there may be issues, motions to suppress, things that may result, and you may not have a choice but to reduce one down to try to at least get some provisions in there to prevent it from occurring in the future. So even with a reckless driving case, there still may be, and normally always is, that the defendant's required to complete an alcohol and drug assessment and the DUI risk reduction school. But
And
DUIs
so
have
would this
become very
bill,
difficult.
would this apply to those kinds of cases, or is it just knocked down in that situation and this would not apply to that.
Well, there is a provision that talks about alcohol related offense. So if you have someone that has ingested some type of illegal substance or a prescription, legal prescription, and they have some other alcohol in the car, then that would apply. An ignition interlock would apply. And then a judge could order as part of a person's probation that they comply and get an ignition interlock device.
Okay, and then a final question, as mentioned earlier about the 100-mile, over 100 miles, this wouldn't apply to them. Well, what would happen? Would their license just be suspended if they were not able to get?
It would be the normal suspension process.
Okay. Thank you. That's everything, Chairman.
Okay, thank you. Representative Lott.
Oh. I'm sorry, I was just asking, I was gonna ask for a little clarification, but I think, do you have speakers, Chairman, that will be speaking after? Or are we moving on? Do we have speakers that have signed up?
We do have a large number of speakers that have signed up.
Okay, good. I think they'll answer my question.
Okay.
Thank you.
Thank you. Representative Evans.
Thank you, Chairman. I think I'm going to be in the same situation as Chairman Lott, because the cost is a little, I heard the cost was a little bit different when I was talked to yesterday. So maybe we'll hear that from some of the other speakers. I think so. Thank you so much. Yeah.
And I think different vendors are a little bit different, but.
Okay. I think it was the upfront cost, I think is less than 600 is my
Of course,
understanding.
DUIs anymore aren't cheap. I mean, you put yourself in that position. I think many times you end up spending $10,000, $15,000 before it's concluded.
Well, that's true too. Yeah. Thank you.
Let's go ahead and hear from some of the individuals. Anyone else that you're,
This gentleman here from the Prosecuting Attorney's Council would like to.
okay,
Oh, he's good.
okay, all right. Well, then let's start down the list here and see if we can get, and please remember that our time is, we want to hear from you, but our time is limited as we have 3 bills today and we have a large number of individuals that have signed up. How about Frank Harris? Is Frank? Sure.
Quick question, Chairman Hitchens. Chairman, I know the Prosecuting Attorney's Council just sat down. Is it safe to assume that they are supporting this measure by virtue of them being
I think
here
all
at
the law
your side?
enforcement agencies in the state and the judiciary and certainly some of the groups, MAD's going to be here, SAD's going to be here.
Just wanted that to be on the record. Okay.
Yeah.
Thank you.
Thank
Okay.
you, Mr. Chairman.
Yes, just tell us who you are.
My name is Frank Harris. I am the Director of State Government Affairs for Mothers Against Drunk Driving. And just real quickly, I just wanted to clarify the cost issue. I've been advocating for these laws throughout the country for the last 14 years. And for 6 months, it costs, including the installation and deinstallation fee, the monthly monitoring, it costs roughly $600 in total. That's a liberal estimate. Now, if you're indigent, there's an affordability program, which a judge in where I'm born in Wisconsin called the discount double check. You get it at 50% the cost. So if you can't afford it, you have it, you can get it. Whereas right now, under current law, you can't. If you can't afford an interlock, they just say, oh, you just have a license suspended, and society has to hope for the best that you don't drive drunk. But like I said, I'm with MAD. We've been advocating for these laws for the last 14 years. 34 states have laws like this that are already on the books, and these laws are effective in changing behavior. It's not necessarily really a punitive sanction, it's a rehabilitative sanction. And what we found, actually not what we found, what the Insurance Institute for Highway Safety found in studying these laws is that they reduce drunk driving deaths by 16%. So laws like the proposal by Chairman Hitchens has been proven to reduce drunk driving deaths by 16%. That is a big deal. Because in Georgia, a quarter of all fatalities are caused by drunk drivers. And drunk driving deaths, according to NHTSA, has gone up by 9% during the pandemic somehow. So the fight against drunk driving is far from over. This legislation will go a long way in stemming and turning the tide. And most importantly, this bill will help create a future of no more victims. And Mr. Chairman, I do have a victim from MAD who signed up, who I could speak if that's okay.
Sure.
And I'm done, but I can answer any questions as well.
Okay, let's see if there are any questions for you. Any questions at this point? Okay, it is my understanding that 34 states have already implemented this.
Yes, Mr. Chairman, 34 states, including Alabama and Tennessee, neighbors to the state of Georgia do. They're in different variations, but we call them all offender laws, like this legislation, where the only way a person can drive during their license suspension period is if they drive with an ignition interlock restricted license. And again, this allows that person to be part of society. Because we know just saying, hey, we're taking away your license, good luck. I mean, again, luck and hope is not a winning strategy to stemming the tide against the violent crime of drunk driving.
Okay. All right, let's hear from, if you'll state your name and.
My name's Debbie Hawkins. My husband, Al, is here as well. We were asked to come as a victim family. I'll be very honest, 1983, we got married. 1993, we had our first child, Alita. 1995, we had our son, Anthony. Fast forward to 2016, September 10th, we got a knock on our door at 5:30 in the morning, and my husband opened the door and there were 5 police officers standing on the other side on our porch to tell us that our son was killed. We, of course, all these thoughts went through my head. It can't be Anthony. It's got to be somebody else. However, we live in Bear County, which if you're familiar with Bear County, it's a small county. Our daughter played soccer with the sheriff's niece. So he knew when he knew right away that it was us. It's devastating to this day. 5.5 years later, it's devastating. It's frustrating. We still miss him terribly. We're very thankful to have a wonderful support group with MAD and our family and friends. And honestly, God's gotten us to this point, and we really believe that this is where God wants us to be, to help other families not go through what we're going through. I think probably the hardest thing was to have our daughter get married and he wasn't there. We have a picture of, it's a beautiful picture. She's holding a picture of him. Our now son-in-law even had a picture blown up of him to stand in the groomsman line because that's where he should have been. But he was not, because she drank, and the establishment that she was at did not stop her, actually walked her to her car. And there's video evidence of that. That's how and I can't go into many details, but the person that she was with followed her. She turned onto 316 going westbound in the eastbound lane. And within a quarter of a mile, not even, she hit him head on. Her flat headlights were not on. And we heard that from someone that was behind our son. I worked at one of the schools, and she happened to be a parent. And when she put the names together, she came to find me. Something needs to be done. I mean, I talked to other people. There's a couple other people I've gotten to be friends with. There needs to be something done. And I guess I kind of sit there and I understand the cost can be hard. Thank you. But at the same time, that $1,500 or whatever it would happen to be, we lost our son because she decided to drink, and the people at the establishment did not do their job as well. And 21 years old, and he's gone. He was going to school online, and he was working at Domino's, and the owner of the Domino's came to his service and said he was on the fast track to wonderful things. And we are so sorry on a personal level and on a corporate level. And I know I'm getting excited. I'm sorry. There's so many things we miss him for.
Can I speak?
Yeah, sorry.
Go ahead, Mr.
I'm Al
Hawkins.
Hawkins. My only statement is if the numbers are right and they've been looked at and discussed, and, if you're going to drink and drive 70 odd times, what's the difference? It's going to happen again. It's inevitable. You've already exercised, an attitude and a desire to do something. You're going to do it again. So stop it now. If they've already done it, and by God's grace, they didn't hurt anybody else, why let them have another chance? That's all I could to say. And I thank you all for.
Well,
for
thank
hearing
y'all
this.
for sharing that story, and we offer our sincere condolences on the loss of your son. That was a powerful story. We do have two individuals that are wishing to speak or ask questions. Representative Lott.
I'd just like to say, I don't have a question for you, but I would like to say thank you for being here. Thank you for testifying. Thank you for advocating, because it really does matter. And I'm sure in your life, you probably never pictured yourself sitting in front of a committee at the Georgia State Capitol, but here you are, and we are appreciative that you're here. And there are
Absolutely.
plenty of lives in the state of Georgia that will value the fact that you are here. So thank you.
Thank you. That's our hope.
Yep.
That's our hope.
Chairman Petrie.
Yeah, well, likewise, thank you. Thank you for being here. I'm so sorry. Terrible story, and you're doing good today by being here. We're very sorry for you. I lost my father the same way. My question for you, but there's nothing like losing a child. It can't be anything like that. And so I'm so sorry. This individual that killed your son with their reckless behavior, how many DUIs did they have before? Because some of the things we'll discuss in this measure about first time, second time, did they have DUIs previously, out of curiosity?
No, sir.
This was a first time with
is the
this
first
particular
time, and-
individual.
Right. And her husband had no idea. He said she'd never done anything like it.
Yeah,
Of
of course.
Yeah, he was not with her.
Yeah.
So
yeah.
she was with a group of people. We do know that the first place that she was that night, they had kicked her and her friends out of there many times due to being a little bit rambunctious
Right,
because of the drinking that had happened.
right.
Um,
Thank you again, and very sorry. Our condolences.
Thank you.
Thank y'all so much. We'll move on to some of our other individuals that want to speak. Brandy. I'm sorry, you were reading me correctly, but me not being able to pronounce that. Thank you.
Absolutely. Brandy Axtell.
Excellent. Thank you.
Thank you for holding this hearing and for being here today and considering this legislation. My name is Brandy Axtell. I'm the Senior Vice President of Responsibility Initiatives at the Foundation for Advancing Alcohol Responsibility. We are a national nonprofit. We've been around for 30 years now to fight impaired driving and underage drinking. We are funded by the distilled spirits companies who care greatly about preventing drunk driving and preventing the deaths and injuries caused by it. I'll be really short today. You've had some fantastic testimony. I've worked in the DUI legislative arena now for 30 years. This is one of the most well-researched and effective countermeasures that you can put in place to stop drunk driving. One thing that we're seeing nationally is that the impaired driving problem is evolving. It's often involving alcohol and a combination of other substances, not just one other substance, often 2, 3, 4. When you combine substances, it makes it really, really dangerous, even more dangerous than drunk driving, which is insanely dangerous. If you have a technology that can cut the drunk driving part out, it would have huge ramifications for safety. And over the last 2 years, we have seen historic increases in traffic fatalities. Roughly a third of those are usually alcohol impaired. It's critical that we do something. And I'll make one last point, which is why first offenders? Why not just repeat offenders? Well, a lot of times a first-time offender, it's just the first time they've been caught. Most impaired driving offenders have either a substance use disorder or a substance abuse problem. And about half of them have a mental health issue that's not identified and goes untreated. So if you have an interlock on a person's car, that enables people in the justice system to then take the time to screen and assess those people and hopefully get them the help that they need for their problems. I know that Georgia has some fantastic treatment courts. They have fantastic outcomes, but ignition interlocks make it impossible to drive drunk. And it would be a huge, huge step forward in preventing death and injury on the roads in Georgia. So we ask for your support. Thank you.
Thank you. We have one question from the committee. Representative Rick
Thank-
Williams.
Thank you. This thing can't detect marijuana or any other drugs. Because I'm like Jesse, I lost my father to someone who was driving under the influence. At the proper time, I just want to make a motion. We do pass.
I'm not going to recognize that motion just yet because we still have some individuals that wish to be heard, but I will come back to you. Thank you.
I'm so sorry for your loss and your loss and your loss. And I hope that we have a day sometime in the not too distant future where we're not talking about this anymore because it's 100% preventable. And thank you.
Thank you so much. We appreciate this very much, you coming today. Rick Baya. Rick, go ahead.
Yeah, thank you, Mr. Chairman and distinguished members of the committee. Rick Burt. I have the honor of being close, very close there, no worries. I've been called worse. I have the honor of being the president and CEO of SAD, Students Against Destructive Decisions. We have almost 100 chapters in middle schools, high schools, and colleges across the Great Peach State with over 18,000 members. And I'm here today to add their voice to this chorus, urging your passage and your support for this measure. Apart from the incredible testimony you've heard already, this measure also makes this technology available to individuals under the age of 21 through the amendment, and continues to build a culture of safety. We know that early intervention is an important countermeasure, just as you've heard, to curb mental health issues, substance abuse issues, dependency. And so making this technology really makes sense. It's a sensible solution, and the students of Georgia, who are not the leaders of tomorrow, may sound cheesy, but they're the leaders of today, they add their support to this measure, and I urge your passage. I'll provide my written testimony with a few other remarks, but thank you, Mr. Chairman, and the committee for the opportunity to speak today.
Thank you so much. We appreciate you coming. I'm going to call on you. Any questions from the committee? Okay, thank you. I'm going to call on Jill Travis, and Jill is on our Zoom. Jill, are you there?
Yes, I am. Good afternoon, Mr. Chairman and members of the Public Safety Committee. Thank you, Subcommittee B. Thank you so much for having me today. I'm joined with two of my guest lawyers, Aaron Gersten-Sang and Rick Reisig, who are going to be available to help me with any technical questions that your committee may have to offer. The General Assembly has historically looked at these kinds of issues with some kind of guardrails. And what I mean by that is, obviously, you all can recognize that this is a huge moneymaker for this ignition interlock industry. Similarly, there was this was an industry when DUIs, when it became law that we wanted people to go to DUI schools and attend risk reduction programs. And what the General Assembly did was say, we need to put some restrictions on these private companies that are going to make money on by our laws, so that it's all fair. So for DUI alcohol programs in law in 40-5-83, we set what the fees can be for assessment, we set what the fees can be for intervention, and most importantly, we require the DUI schools to reimburse the state $30 on each person who's assessed. So what I'd ask for you all to consider is to provide some of those safeguards.
Jill, let me interrupt you just a moment. Will you please tell the committee who you are?
Oh, I'm
That some of
sorry.
them do not recognize you like I do.
Okay, sorry. My name is Jill Travis. I am the executive director of the Georgia Association of Criminal Defense Lawyers. Some of you legislators will recognize me as former LC 29. So here I come to you in a different capacity. Where I was going with this was, many of you have picked up on this issue of costs and how much is this going to cost? Well, there's the installation fee, the de-installation fee, the monthly lease fees, the calibration fees, the lockout fees, the security deposit, the mileage fees, and fees by another number. What we'd ask you to consider doing is to revise the bill so that the legislature puts some restrictions in place. So these IID providers that today, maybe the expenses are only only $600 because $600 is a substantial amount for most people. But tomorrow they could raise them to $800 and then $1,000, and then it keeps going up. Without the legislature putting any guardrails in place, you're preventing it. So we would ask that you consider, and I've got language and I can submit that to you, Chairman Green, that you actually lock in these fees. And also, one of the other things that the ignition interlock companies do is they require contracts, and they can require contracts for longer than the ignition interlock device should be on the car. So we would want to prevent that. And lastly, with regard to this issue, we'd ask that you require the ignition interlock providers to give back, because DDS and the courts are going to be responsible for managing all of this. You require the DUI schools to give back. You haven't provided any give back from these providers. And as Chairman Hitchens indicated, DUIs are very expensive. So the other solution that we would propose to you, if you are looking at the bill at page 22 in section 10 of the bill regarding the fines for 40-6-391, the current fines for a first-time DUI is $300 to $1,000. So when we talk about a DUI conviction and the consequences of a first-time DUI arrest and conviction, the fines that are involved in that, the fines and fees, let's just say it's a $300 fine, then you double that when you add the surcharges, then you've got the DUI school you've got to go to, which is capped by law at $395. Plus the person has to get an evaluation. Then they have to go to treatment if that's necessary. Sometimes they pay for a lawyer. So it all adds up. If the General Assembly is going to decide that, yes, we want the ignition interlock companies to make money on these situations so that our public is safer because they're driving with ignition interlocks, let's make it the same for the offender in terms of what the consequences are. Let's reduce the fees that are paid by those that are caught in this trap. And oftentimes, this is the wake-up call that changes people to change their behavior. Another consequence that happens in some other areas of the code is that what happens when the ignition interlock provider doesn't do what they're supposed to do, doesn't give the hardship exemption, doesn't reduce the fees. Is there any consequence to them? The answer to that is no. But you could do that by amending 4312.8. It's in another bill that we've provided language to the advocates on this. I want to talk to you specifically about section 12 of the bill and the financial hardship. And I think there's some confusion about how this will actually play out in reality, because as you can well imagine, many people are not going to be able to afford this device. First of all, the determination of indigency is only made after a conviction. That's at line 771. So a motorist that has had this device required as a bond condition doesn't have any way to get a fee waiver. There's no way to reduce it. So you need to move the determination of indigency earlier. With respect to the determination of indigency, the truth is, yes, there are ways in the code that we reduce fees, but unfortunately, the bill here doesn't take advantage of what judges already know. what judges already know is they can reduce fees and fines when somebody's unable to pay their probation fees, and they look to 42-8-102 D and E to determine if somebody's indigent. So when our judges are so busy, why do we not use this same standard? Why do we import now a different standard that we're going to use for ignition interlock devices? It just doesn't make a lot of sense to bring in a new indigency standard. And the other thing is that I think, I'm going to get to this a little bit more in a moment, but I think that there was an oversight in the drafting with respect to limited driving permits. There's no hardship. There's no hardship exemption for a limited driving permit. So I can't remember who asked the question. I think it was Representative Williams who asked about DUI drugs. As I understand it, this bill is supposed to be written in a manner in which somebody that's DUI drugs can still get the limited driving permit that's available by law. However, when I'm reviewing the bill, I'm not seeing that in the language. And I'll point to that in a minute. Another question and issue that we raised for you is, shouldn't we limit this ignition interlock to be on the person's car that they use? If you look at lines 724 and 725 of the bill, it requires the ignition interlock to be on all vehicles registered in the person's name. So if you have, if I have a car and my son at college is driving it and it's registered in my name and I get a DUI, I have to put an ignition interlock on his car because it's registered in my name. That doesn't make sense to me. And then there's no exemption in here for how to deal with company cars. In terms of what I'll just phrase as like questions or issues, and those what I've just stated are concerns about the current draft. I don't think you've provided for limited driving permits for DUI drugs. That is a discussion that we've had with the ignition interlock provider advocate. And I think that in order to do that, you'd have to put that in section 3 of the bill. And there is also a lot of cross references in the bill having to do with limited driving permits. We just got a copy of this bill like less than 48 hours ago and just trying to work through it all. So I can't give you all the lines and places that it might have to change.
Okay.
I've got just 3 more issues.
Okay. All right. Go ahead, because we have some questions that might clarify that you might be able to clarify. Go ahead.
Okay. I'm happy to stop for questions. I thought if you want to interrupt for questions, I'm happy to pick back up.
Okay. Chairman Petrie.
Actually, my question is to Chairman Hitchens, but related to some of the comments. So Chairman Hitchens, my understanding is to this concern about some organizations profiting by providing a protection to the people of Georgia. Don't you contemplate a free market, robust system of providers competing for this business everywhere, speaking to concerns about exponential increases in fees and so forth?
Well, I think it's the American way, to be honest, capitalism. But we have checks and balances, and that's certainly one of them, competition. And I think I read in here, and this is 30 pages, and we just got the last update yesterday. But somewhere in here, it says that the Department of Driver Services has regulatory authority over a lot of this.
Thank you, sir. That was my understanding as well. There would be vigorous competition here.
And just like in any law, they make rules and regulations to in addition to what the law says. They have the authority to make a difference. When driver's license left the Department of Public Safety, we spent 6 months voting on all the rules at the Board of Public Safety that were in place for driver's license to get them off the books.
Thank you, Colonel. And I appreciate the good bill.
Do we have other questions from the committee? Okay, Jill, you have 1 or 2 other. We're running out of time. It's
Yes.
what it is.
I understand. But I'm sure you want a full vetting of this bill So at any rate, yes, I understand there's rules and restrictions, but the rules and restrictions are never going to say the IID provider has to pay money to the state. So that's something that would be missing. Another issue in the bill is how about removing the device from the car. We do ask for drivers to be given credit for time served, and that was put into the bill. And that the device is allowed to be removed, but there isn't any language that prevents another charge from that. And the removal of the device is only post conviction. It's found at lines 728 and 730. So in the scenario where somebody goes out, after the bill passes, goes out, gets a DUI, condition of bond is to have an ignition interlock device. They've served their 180 days. They can't get it taken off because of the way the language in the bill is written. I think that was a drafting oversight. There's also changes with regard to revoking the ignition interlock device. If I'm directing you to lines 401 to 409, under current law, there's a requirement that there be a conviction, and that language got removed in the rewording. There's also some other typos that I'm not going to bring to your attention right now. And we also have some concerns about the reporting requirements. That's the gist of our concerns. I would ask that the committee consider holding this, and I will say that Mr. Lindsay with Denton's has been very cooperative with us and has incorporated some of the changes that we've requested. We just haven't had a chance to get with him about some of these other concerns, because I take him at his word when he tells me that the intent is to provide a limited driving permit for a DUI drugs, but I don't see it in the bill. And I think that the hardship exemption is something that really does need to be worked through, because to Representative Evans' point, the truth is right now, today, I could get a DUI and the judge tomorrow could say, you've got to put it in ignition interlock. This bill does put it in black and white, but that's not a change really in the law. But if I couldn't afford it, I would certainly hope to have some mechanism to be able to still be able to go to my job and support my family.
Okay. Thank you for those comments and your concerns in the bill itself. We do have another individual, several individuals that wish to speak, and one of them is Edward Lindsay.
I'll wait, Mr. Chairman, other than to say that we've spent a year working very closely with the criminal defense bar, with the prosecutors, with the Department of Driver Services. Happy to listen to any additional points that they should raise. We would urge you very strongly to move this bill forward. We've worked and we've shown in good faith our willingness to adjust accordingly. I'm not going to question how much lawyers make through DUIs, but I will say this: unlike lawyers, there are regulations in terms of the amount that is charged for these devices when they are installed and how much they can, and a representative of the industry can speak to that. I will also say that I'm happy to take a look at whatever Ms. Travis has regarding DUIs for drugs. But I have spoken with the prosecutors, and they've assured me that they believe that the drugs, that the LDS is still applicable for the drugs. But if there is any particular problems, I'm happy to work with them. And all we would ask is that let's move the bill forward. And during the time between now and the full committee, if within the next day or two, they will provide me with any additional language, I'll work with the prosecutors to make sure that it's reasonable, and then we can move forward. So we would simply ask that. And with that, Mr. Chairman, if there are any questions regarding the actual fees, we have a representative of the industry here. And I will also point out that the industry will be eating the cost for if a voucher is provided by a judge for a reduced fee. It is the industry, not the state, that will be eating those costs. Thank you, Mr. Chairman.
Okay,
I'll be happy
thank
to
you.
answer your question, but I know time is limited.
Okay, Barry, I think you wanted to speak, just if you'll come up here with Colonel Hitchens. Barry, for those that do not know you, would you please tell us who you are?
Yes, good afternoon, Mr. Chairman, ladies and gentlemen of the committee. Thank you for the opportunity to address the committee today. My name is Barry Schrenk, spelled SCHRENK. I went to work for Mr. Taggart in 1974, bought the company in 1976, and have operated Taggart's Driving School, Taggart's DUI, risk reduction, defensive driving programs ever since that period of time. I'm rather familiar with the language and all the bills that have to do with risk reduction, which basically started back sometime in 1988 under Governor Zell Miller. That's when the first bills were introduced. And I also want to thank Jill, the person who spoke just a couple of minutes ago. After all these years, it's the first time I've heard almost the complete argument that defense attorneys give to the judges when they're trying to get a DUI offended off or getting their case reduced to public drunkenness or reckless driving or what have you. So it was a complete package. Thank you, Jill. I've never heard that before. I'm sure others in the room appreciate it. There's two parts of this bill. One is the philosophical part of it, which has to do with a person who is accused or convicted of DUI having to have an interlock device. There's arguments on both sides of that. I will be honest with you and tell you that I have not had enough time to poll all my members of the association, the Georgia Association of Risk Reduction and Defensive Driving Educators, but there'll be some folks who will be against it. They will want a free pass for somebody the first time out. Others will support it. I support the legislation. I've taught the DUI risk reduction program, the 20-hour program, since 1990. So I've seen a lot of folks in class with a variety of different reasons. And I will tell you quickly that if this was 30 years ago and there were 10 people in class, there will be 9 people in there for DUI and 1 for DUI and drugs. Today, it's 9 people for drugs, who just happen to be caught drinking. That's how serious the problem is. And I mention that because I think we made a serious mistake under criminal justice reform a few years ago when we decided that folks who were charged with drug offenses did not have to attend the DUI risk reduction program, which has a drug portion to it, and it's very important. I would strongly suggest that you entertain the idea of putting it back either in this bill or another bill. Charging somebody with possession of drugs, use of drugs, dealing drugs, whatever the charge happens to be, and fining them, putting them in jail. When they get out of jail, there's really the same person. Basically, what they really need to do is to sit through the risk reduction program and maybe change their ways. That's what the statistics show. First of all, basically the way the industry works, at one time, there were a number of driving schools who got involved in providing the interlock units. In the law, it's written that the installation fee is $75. So I'm sorry, Colonel, it's not $600, it's $75 by the law, and it's $75 a month. Now, for that $75 a month, for whatever the period, 6 months or a year, whatever the period happens to be, the individual has to bring that vehicle in once every 34 days. And we actually put a black box on it and test it to make sure that somebody hasn't disconnected it or done something else to that unit. If that happens under the rules and regulations of the Department of Driver Services, we're required to immediately report it to the department, and then they take action against the limited permit. All the programs that install these units are licensed by the Georgia Department of Driver Services. Everyone has to fill out an application. They have to send in fingerprints. They're checked for the GBI and the FBI. There's background investigations, and the department has monitors on the programs. So this has been going on for a number of years. I mean, back since maybe 1990 when it first started, and in fact, they were licensed. The schools were licensed prior to that, probably in 1978. And but the rules and regulations have been developed. It's very tight, and very proud of the Department of Driver Services in that if someone is doing something wrong, they can take action, and they do take action. I have a couple of questions about the administration of the program as it's laid out in the bill. And one is to set the fine for interlock providers if they do not accept financial waivers from the court or the department. Well, that's brand new. At the present time, the only waiver is the judge decides whether a person is indigent, and then they don't have to have the unit on there. It's just that they don't have one. It's that simple. So it looks like this bill would change that system, and the interlock providers, hopefully it's the manufacturers and not the installers, are going to have to provide a free unit for some of these folks. The installation fee, the $75 installation fee, takes an average of about 2 hours to hardwire one of these units. So to pay $75 to have a unit hardwired in your car, relatively speaking, anything else that you can have done to your car, that's a very small amount of money. And and I will tell you, after teaching classes with lots and lots of people and with DUI and alcohol problems, if they need $75 that night for wherever they're going or whatever they're buying, that's petty cash to them. So it's just not a big deal. There are people who are indigent and should be helped, but we need to clarify who's going to provide that help, who's going to give the free service, because I'm sure the installer, the driving school, who in many cases it might be the husband of the owner, still wants to get paid for installing it. It takes about 2 hours. Now, on occasion, the install fee is a little higher. It could be an extra $150. If you drove in to have the Interlock device installed on your 2021 Mercedes S550, it'll probably take an extra 2 hours, maybe 4 hours, because wires have to be run through the firewall. There's all kind of electronics in the car, and it takes about 4 hours for one of these late model expensive cars to do it. So there's nobody really making any money on the install. It's if anything, they're probably getting a break compared to what they'd have to pay somebody else. And then that monthly fee, for example, not only the test, but something can go wrong. Somebody comes out of work one night and their car won't start. They can call an 800 number and they can do it the manufacturer can handle it electronically and get the car started. So there's a lot of service for that $75 monthly fee. In the bill, it states that the person has to take either the risk reduction program, which is a 20-hour specific curriculum, or the 6-hour defensive driving course. That 6-hour defensive driving course is all about defensive driving. It has nothing to do really with DUI and the use of drugs, alcohol and drugs. So in other parts of the code section, Title 40, it already says that they cannot use the 6-hour course for the 20-hour course and vice versa. The problem is if the bill goes through the way it is, if that's not taken out, you will have school owners, hopefully they're none of my friends, when someone calls and says, I have to take either the 6-hour or the 20-hour course according to the law, they will say, oh, we don't teach the 6-hour course. You have to take the 20-hour course. Why?
What section is that you're talking about?
40-5-83, it's
In
all
the-
through in there. Oh, and on the bill?
Yes.
Mr. Chairman, to be honest with you, I didn't read the bill until this morning. I was tied up for
Okay.
a couple of days with some family matters and just read it. It may be in 550, line 550. I'm not sure, but I can work with Colonel Hitchens on that,
Okay.
find that. But someone who has a DUI or a drug problem does not need to take the 6-hour defensive driving course and learn where you stop at a stop sign. So that's one suggestion. Let me see here. Oh, in part of the bill, it talks about an evaluation. An evaluation is separate. It's usually an individual who is licensed or should be licensed by DBHDD. I would suggest that be added in there so that folks who have to take the assessment, an in-person assessment runs about a half hour, 45 minutes for a person who has a psychological background. My suggestion is that they should be on the evaluator and treatment list for that department to make sure that somebody doesn't just set up a business with a sign along the side of the road and say, hey, for $600, I can get you out of your, out of this. You don't want to have to go to treatment or something. I'm probably running out of time, but if anybody has any questions, I'd be glad to answer them.
Do we have any questions from the committee? I know our attorney has just left for another meeting. Are there any questions here? Oh, yes, Representative Evans.
Yes, thank you so much for coming today.
You're welcome.
I think my kids all took driving from your school too.
Thank you
so-
for the business. I appreciate it. Hope
So
they're
I-
doing well.
Yeah, they're doing well. Thank you. I hadn't really put this together. So do you anticipate that the driving schools will be the providers of these interlock devices or like
I think
franchisers
there's gonna
or
be
something?
I think there's going to be an increase in business.
Mhm.
I don't think it's going to be a great increase in business, but there will be an increase in business. But as an example, Kennesaw Driving School is owned by friends of mine, a couple. And they actually handle Paulding County from Kennesaw. And because the folks who were handling that business in Paulding County, it just wasn't worth it. They couldn't make enough to stay in business. So they actually go
This
out to
program?
Paulding County, pardon me?
They have this program?
This program,
Oh,
yeah,
okay,
the Interlock program. Actually, the husband goes to Paulding County to a driving school there, and at no charge from the driving school owner, she allows him to use their space. And he installs on the average of 4 to 5 interlocks for the whole month in Paulding County. Now, it's sort of a rural county, but still, excuse me, I said Paulding. He goes to Carroll County and does it. So there's not a whole lot of business now, and but it will increase. There's no question about that. But I mean, just kind of like the doctors are really busy giving vaccinations, but you're not going to stop the vaccination because the doctors are making money. I mean, that's.
Okay. Does that answer your question on that? Thank you. We appreciate it. Do we have anyone else that wants to speak for or against the bill? Okay. All right. Thank you, Barry. We appreciate that very much. All right. Now we come down to the what is the wish of the committee? And I will go ahead and recognize Representative Williams, who I told I would come back to him.
Recommended do pass.
All right, we have a recommended do pass, and we have a second. Do we have any further discussion? Okay. Yes,
Yes, I'm in favor of moving it forward, but I do hope that the colonel will work and Mr. Lindsay will work with Ms. Travis and Barry and whoever. Yeah, yeah, great.
It's been a process, this is about the 4th iteration and we've met, as he already identified, we've met with all the groups interested. And, it's 30 pages, 32, 33 pages long and we expected there would be some differences of opinion, but it all collapsed into place.
all right, thank you. We have the motion and a second. Any further discussion? Okay, those in favor of moving this bill forward to the full committee, please signify by saying aye. Those opposed? Okay, the bill moves forward to the full committee. Yes, thank you. Yes, Colonel, I'm still in here for your meeting. Well, I think there's 3 of us in here that should be in there. Okay, thank y'all for the testimonies, and now we move forward and Representative Gully, if you would, please. You want to speak from the podium or you want to speak from the table? Yeah, you look tired. All right. Representative Gullett, please. If you'll just give us a quick synopsis.
Yeah, we'll move fast.
Thank
This
you.
is a substitute to the bill. I turned it in yesterday.
It's LC 393260S. Is that the one we have? Okay, great. So this is related to the Georgia State Identification Fund. And all this is doing is adding COVID-19 as one of the qualifiers for the death benefit. Basically, this mirrors the federal benefit language and guidance that they offered. I think right now they would say there's no current, directive outlining when the deceased qualifies for the benefit today. That's causing DOS staff spending expensive time investigating the claims. Right now, I want to say also that this is time-based, so it limits the exposure of how long there's an end date of when you've passed from COVID, of when you would qualify, and that's December 31st, 2021. So the key parts of this, I know there's a bunch of changes. A lot of those changes are really just legislative counsel making the bill better. It's not really substantial or substantive to what we're talking about here, but it's really line 111 through 114. Department shall consider death of public safety officer, which occurred between March 1st, 2020 and December 31st, 2021 to have occurred while in the line of duty if the public safety officer was diagnosed with COVID-19 within 45 days of such public safety officer's last day of duty. That's the key. Like I said, there's a number of changes, but those are really just legislative counsel cleanup language for it. And I'm happy to answer any questions about that.
And you do have a question, Representative Riggs.
I just want to make a motion to pass when the time's right.
Okay, we have two individuals that.
They're my phone a friend. So if we're going to move forward, we're good with that. That's okay.
Okay. Do we have any? All right. We have, do we have any further questions or discussions of the author before I call on Representative Riggs to make his motion? All right, we have a motion for do pass. Second on that. Any further discussion? And this is the substitute to House Bill 1145, which is LC 393260S.
That's correct.
Okay, so we all know what we're voting on, okay? We have a motion and a second. All those in favor of the motion, please signify by saying aye. Those opposed? Okay, it will move forward to the full committee.
Thank you, guys.
Okay, thank you for being patient. Thank y'all for coming. Okay, we have, and thank you, Senator, for being patient with us. You have Senate Bill 358. Senator Kirkpatrick, if you would, please come on up.
Thank you, Mr. Chair. And if it's okay with you, I've got Mr. Ashton Harper here from the Georgia Public Safety Training Center.
Okay, good.
Okay, Mr. Chairman, members of the committee, this bill should be pretty straightforward. It was developed in conjunction with the Georgia Public Safety Training Center and also Colonel Trish Ross, who used to be the head of the Vector Center down in Warner Robins. And now, of course, she's the commissioner of DVS. And that center, as you know, helps veterans transition from military service into employment and civilian life. So what this bill does, and I didn't say the LC number, it's 480525S. And the meat of the bill is on page 2. We already have a tuition reimbursement program that is available to police chiefs, wardens, emergency services, personnel, and communications officers. And that does not include travel expenses. And this would extend that to members of the military coming out of service and retired military members, subject to appropriations. And in talking to Chris Wigginton, who's the executive director down there, he feels that this would probably not be a large number of people and that they could probably absorb it in their existing budget. But if the program was wildly successful, which we would hope would happen, then we could come back and add funds in the amended budget. The fact of the matter is that we have vacancies in a lot of our law enforcement agencies that we can't fill. And we want veterans to be able to apply for those positions. and this should make it easier for them. So I would be happy to answer any questions. This passed the Senate unanimously, and I would hope to get a similar result on the House side. Thank you very much.
Okay, thank you, Senator. We do have some questions. Representative Rick Williams.
Make a motion, do pass.
Okay. You're having a good motion making dialogue today. Let me see if we have a question here from is it Josh?
What's it? Clark. I just want to comment on this, Vector being in my district. I know there's a second Vector that's been appropriated for this year. And I believe that's going into Cobb County and into your district. So it has been wildly successful. A couple of years ago, it came to our attention through some people back home with people transitioning out of Robins Air Force Base. And we have worked to reduce the cost to service members already by coming up with an adapted course for service members so that they just have to kind of learn the laws of our state, but it takes the training that they've already received on their firearm or any other type of training that they've received in the military and applies it to that. And then it has the reduced, I think instead of the full load, I think it's only a 2-week course that they go through. So it's already reduced, and this would even help them if it's not something that is appropriated, that then this would come into effect. So I thank you for this bill. And since somebody's already stole the motion there, I will yield.
I'm not sure they've stolen it yet or not since I called you.
I will yield to the gentleman from Milledgeville.
All right, thank you, Representative Clark. All right, we do have a motion, and I assume we have a second from Heath.
I will second the motion.
Okay, Representative Clark, thank you. Do we have any further discussion? Okay, I'm gonna call for the question then. Those in favor of Senate Bill 358, please signify by saying aye.
Aye.
Those opposed? No opposing? And you have.
I'd just like to say to Representative Clark, Chairman Clark, Robins Air Force Base almost was built in Milledgeville. You just lucky.
Well, Milledgeville profits from it anyway.
Oh, they all profit from it. Senator, you have your bill, and if you'll, this will be moved on to the full committee, and we'll let you know on that. Just watch for a memo from the chairman.
Thank you so much.
All right, thank you. And thank you for being patient today. We appreciate that. Thank y'all for coming. If there's no further business, we stand adjourned. I've got one more now.